Within days of starting your medical malpractice lawsuit, the defense reaches out to your attorney and makes a settlement offer. What do you do in that instance? Do you take the offer? Do you disregard it? Would you like to know the answer? Come join me for a walk along the beach as I share with you the answer to that question. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. Within days of starting your medical malpractice lawsuit, filing the papers called a summons and a complaint, which actually starts your lawsuit, and having served those documents on the people you are suing, the attorney who represents the doctor now reaches out to your lawyer and says, we would like to settle this case before it goes any further. What do you do in that instance? First, I'll tell you what you do. You listen to whatever offer comes in. The defense attorney makes an offer. They tell your attorney that the maximum insurance that the doctor has is $1.3 million. And that's all he's got. And now the defense attorney tells your lawyer that they are offering $1 million to settle your case without the need to go forward with litigation. What do you do? Well, the most important thing to remember is you have to have a conversation with your attorney, a detailed conversation. And that conversation should center around what your ultimate goal is as far as bringing this particular lawsuit. Remember, these types of medical malpractice cases, these accident cases, and even these wrongful death cases, they're designed to try and obtain money as a form of compensation for all of the harms and losses and damages that you suffered as a result of someone's carelessness. When we go after a particular doctor or hospital staff, we are trying to obtain money to compensate you for all of those damages and all of those injuries. Now, when the defense attorney tells you, listen, this is the maximum available insurance that we have on behalf of the doctor for liability purposes, for medical malpractice, now the maximum that you're going to achieve if you are successful is $1.3 million, according to what this attorney is telling your lawyer. If, now at the very beginning of your case, the defense lawyer says, listen, we are willing to pay you $1 million to settle your case so we don't have to go through the expense and the hassle and the aggravation of going through the entire litigation process, which could take anywhere from 2 to 3 years from start to finish, what do? You have to sit down with your attorney to evaluate what your risks are of rejecting the offer, what the risks are of going forward, and the possibility that if you reject that offer and now you go all the way to trial, there is the possibility that a jury could give you substantially more money than what this offer is. However, keep in mind that your ability and your attorney's ability to collect whatever money the jury feels you are entitled to receive may be hampered by the availability of what the doctor has. So if the doctor only has a specific amount of money, and let's say the jury comes back and gives you $5 million, claiming that that is the amount of money that fairly compensates you for all of the injuries caused by this doctor's carelessness. Now, you go ahead and try and collect that $5 million and begin to realize the doctor only has $1.3 million in insurance, and everything else in his name is protected. He's got nothing else under his name. Now, what do? Well, at that point, you're pretty much out of luck, and you have very limited options at that point. So you have to weigh the risk of rejecting the offer. You have to weigh the risk that there is a potential that if you go through the litigation and go all the way to trial, a jury could actually come back and decide that you, the injured patient, are not entitled to receive a dime, in which case you're out everything. The jury could also come back and decide that you, the injured patient, should receive less than what your original offer was. Now remember, during the course of trial, the jury is never told about settlement discussions. They are never told about negotiations. And they are never told about any offer that has been made previously. So the jury doesn't have any idea or clue about what has gone on prior to what happens in the courtroom. They don't know that a settlement offer was made early on, within days after starting your lawsuit. They don't know what you believe the true value of your injuries are, All they have to go by is the evidence and the testimony that's presented at trial in order to assess the value of your injuries. So, what do? Do you take the money and that's the end of your litigation and you can never come back? Or do you say, no, I'm going to hold out for the next 2 or 3 years, hoping I can get that additional $300,000 or even more money and get a bigger judgment, and then try and enforce that judgment and try and squeeze money from a stone from a doctor who doesn't have it? That's the choice that you'll have to make sitting down with your attorney to answer those questions. So why do I share this quick information with you? I share it with you just to open your eyes, to help you understand exactly what goes on in these medical malpractice cases. And does it often happen where the defense, within days of starting your lawsuit, offers you a very substantial amount of money to try and settle your case? The answer is no. It does not happen very often. But when it does happen, and a substantial offer is now presented to you, you are now faced with a dilemma. And you have to make that decision about whether or not it's worthwhile to accept the defense's offer, or to maybe even negotiate to see if there's any further ability to obtain more compensation in order to try and resolve this case now rather than later. So why do I share this with you? I share this with you just to open your eyes, to help you understand how these medical malpractice cases work, how these accident cases work, and even these wrongful death cases in New York. You know, I realized you're likely watching this because you have questions or concerns about your own matter. Well, if your matter did happen in New York and you have not yet started a lawsuit and still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a wonderful day.